The final panel. Thank you again, everyone.
Scott Shafer, KQED, California reported. This is our third and final panel for today, and it's titled National Security versus Free Speech. And I think it, in some ways, brings together all the themes that we've been talking about this afternoon. There is, in our country, kind of an enduring tension between national security and the public's right to know, between our First Amendment rights of free speech and freedom of the press, and the government's desire, and you might argue duty, to protect what it sees as our national interest and security. Those values often come into conflict, and as they have this week, in fact, with the latest publication of classified military documents originally obtained by WikiLeaks. The latest documents, I'm sure we'll talk about it, pertain to Guantanamo Bay prison in Cuba and the details of the detainees' lives there, and the U.S. government's assessment of the risk that those prisoners pose. So here with us to discuss that tension between national security and free speech are three, I think, very eminent participants in that ongoing national discussion. Let me tell you who they are, although I think you may know who they are already. Sitting directly to my left is Daniel Ellsberg. In the 1970s, I think it's fair to say that in some ways Daniel Ellsberg became something of a national Rorschach test. After leaking the top secret Pentagon document that became known as the Pentagon Papers, some considered him a traitor, some considered him a patriot, and the path that he traveled from war planner to anti-war activist is documented, in fact, in the documentary The Most Dangerous Man in America, which I understand is going to be screened after we have this panel here. To his left is Lowell Bergman, who is a journalist. He's a producer and correspondent for the PBS series Frontline, and co-founder of the Center for Investigative Reporting, a topic that he teaches at the Graduate School of Journalism here at UC Berkeley. His investigation of the tobacco industry, as you may know, was, for 60 Minutes, was portrayed in the film The Insider. Please welcome Lowell Bergman. And finally, Robert Cole is a professor of law emeritus at Volt Law School. He joined the faculty in 1961 after graduating from Harvard Law School and clerking for U.S. Supreme Court Justice Sherman Minton. Taught constitutional law, jurisprudence, and legal ethics, among other things. Please welcome Bob Cole. So I think what we're going to do here is I'm going to pose a question to each of the panelists, and just to kind of kick things off, and we're going to have a conversation for a half an hour or so, and then we have two microphones here on either side of the room, and of course we'll leave plenty of time for your questions, and I'll give you a heads up when you might want to start lining up with the microphones. Let me begin with you, Bob Cole. The First Amendment states, of course, that no federal law can be made abridging freedom of the press, but freedom of the press is not absolute. Give us the legal framework, if you would, for that, and how it relates to this topic of leaking.
Well, this framework will pick up on Scott's point that freedom of speech isn't an absolute.
Let me just ask if you could maybe bring the microphone a little closer to you so everyone can hear you.
Can you hear me all right? I'm going to give 5 quick points, which I think are the absolute minimum that one needs to know as an informed citizen about First Amendment law as it applies in our context. This is a little bit like saying 5 tips for a winning smile and 5 ways to make $1 million in real estate. But so it's a little bit oversimplified, but I think it captures the essence of the last 70 years of development of the First Amendment law. And there are a lot of qualifications, there are a lot of nuances to what that should be added to what I'm going to say. But I feel that this is, I think this is the basic hardcore. So first, you have to understand First Amendment law as it's done in courts operationally, functionally. You have to understand it as a judicial exercise of the judicial power within its role. The second, The function that we're talking about here is the judges, not jurors, the judges making a judgment of justification in the context of the particular case, on the record in the particular case. A judgment of justification of what? Of whether the First Amendment behavior of the speaker caused or threatened enough harm to an important enough government interest to justify the government in sanctioning the speaker. So you've got now there's a process for exercising this judgment of justification, and it is we're not talking about some generalized cost-benefit analysis. Is this speech worth it against the harm to the government? That's not what we're talking about. For example, a speaker the newspaper publishes leaked documents that are classified by the government documents. So we have to ask, the court has to ask, well, what exact harm has been done by leaking, or is likely to be done by this leaking in this publication? Harm that is prohibited by a statute. And is this harm great enough to justify sanctioning in some way this publication? And in order to decide whether it's justified, then you have to evaluate the harm to the government. Not all harm to the government is significant enough to justify limiting speech. The third point is there is a process for exercising this function of judging justification, and it's highly constrained. It is highly circumscribed by the role of the court and by First Amendment values. So first, there's a technical apparatus for deciding who has to prove what and what you do to call the dots in making this judgment and justification. Because you have to figure out, is this enough harm to justify suppression of speech? Well, prove it to me. Who's going to prove it? How much are they going to use to prove, and so on. And so you have fairly well worked out methodology for doing this in the courts. And the upshot of it is that it's the government's job to demonstrate that this speech is justified to punish this speech. And you can see that if it weren't the government's job, the First Amendment wouldn't be worth anything, because let's take what the government said the other day in the New York Times in response to the WikiLeaks about these Gitmo prisoners. They said, well, we really condemn this because this publication could, how much is could? Would, might, possible, could damage in what ways? Efforts, what efforts? To protect citizens, how? What are we talking about in terms of what detailed protections are we talking about? Or to transfer, in our efforts to transfer detainees, so how would it affect that? You see, you need to both get all of that concrete in order to make this judgment of justification, and you have to be careful that what you're not doing is simply letting the government hide its mistakes and hide its embarrassments. So, if the government on highly speculative grounds can enjoin your speech or punish you for speaking, that means that the good effects of the speech are going to be lost. And so we want to work a balance here. We have to, there's no way to do that without making the government show specifically what harms are going to happen to it. And for the same reasons, the value of the speaker's speech has to be generalized. You can't say, you know, I said, well, the Pope has warts. That's not valuable. What we're doing here, you know, most of this is going to be forgotten in a half an hour. So, at least what I'm saying. Dan and Lowell, I mean, 45 minutes at least. Speech just goes into a huge, gigantic pool of information. And any given speech is relatively, you know, these leaks are pretty important, but generally speaking, any given piece of speech is unimportant. So if you valued each person's speech and said, well, that isn't that important, the government can suppress it, you would end up they can suppress almost everything. So you have to generalize the value of everybody's speech when you're doing this justification judgment. And on the other hand, you have to parse, you have to incrementalize, you have to reduce the government's interest. So you're making a weighing, let's say, of the speaker's interest against the government's interest. You've got to stack the deck in effect in favor of the speaker by generalizing his interest. And you've got to say about the government that we want to know exactly, or relatively exactly, just what harms you're saying are going to occur. And again, you can see the reason for this is that if speech is vague, it could happen, it could do some harm, anything can be suppressed.
And you know, Professor Cole, are there some specific examples that you can cite?
Well, here's one example. I'll give you two quick examples. One is in the Pentagon Papers itself, which is the paradigm case in this area. And what the court very clearly said is the whole point here, the question is, has the government met its heavy burden of, there were 6 justices who held in favor of the New York Times and the Washington Post. Those 6 could only agree on one thing, which was that the government had not met its heavy burden of proving that this publication would harm its interest sufficiently to justify prohibiting it. And so what that means is that secrecy, clearly secrecy per se was breached. What that means is that secrecy per se, the general class of secrecy, that can't count as a government interest sufficient to justify the suppression of speech. It's too general. That's the implication of the case. And then last year, in a case that's a terrible backsliding, in my opinion, called Holder against the Humanitarian Law Project, the court upheld 5-4 a provision, a federal statute that makes it a crime to provide material support to terrorists. And they applied that to speakers who were trying to teach the Tamil Tigers how to use the UN, how to use the International Court to prove its case, to show that it needs to have protection under international law. It's a normal speech function that you would think. Well, what the court said is, well, it could be that tactics like this could buy time for these terrorists, and therefore the government's interest justifies suppressing the speech here and counts as material support for terrorism. Now that's a terrible backsliding from the general Pentagon Papers notion, which is prove it. This is very vague, very general. So for us then, the crucial step, I've said, tried to give you a brief summary of this constrained judgment and justification process. The crucial step for us is what is the process of administering and identifying the government's interest. And the point for us is that national security is not a meaningful, operationally meaningful government interest. Invoking national security at large will not justify, should not, and even though you have backsliding cases like the Humanitarian Law Project, doesn't justify suppressing speech.
Suppressing or prior restraint?
Now,
because I mean, I think people get confused.
Just explain the difference.
I'm using suppressing to mean an injunction. That's what Lowell means by a prior restraint, an injunction against the press. I'm using it to mean criminal prosecution, the Daniel Ellsberg type case. I'm using it to mean civil penalties, which have also been tried. In the conventional wisdom, and whenever someone says conventional, that means they think it's wrong. In the conventional wisdom, prior restraints are given the greatest protection. Now, in my view, prior restraints should be given absolute maximum protection. But there's no reason why other things shouldn't be given the maximum protection also.
But I think that
well,
what people get confused about is that
you will find language. You'll find language that says prior restraints get the highest protection. When you understand the Pentagon Papers case, you need to bear that in mind. That language